Good day and welcome to this week's episode of Strictly Legal on WESN Content Capital. I'm your host, Rondell, Donawa, attorney at law. Once again, I'm happy to be here. I hope you did have a fantastic holiday yesterday celebrating Spiritual Shouter Baptist Liberation Day. So this week we are going to speak about the role of the AG, meaning the Attorney General, in our system, and also we're going to tie it into the recent issue relating to the former Attorney General Faris Al Rawi and, of course, the Chief Parliamentary Counsel, whereby there was a lot of different back and forth communication in the public domain, which some states or some suggest which would have led to him being reassigned to another ministry, that is the Ministry of Rural Development and Local Government. Of course, we have seen further that the new Attorney General, Reginald Moore Senior Counsel, would have sought some legal advice from his attorneys relating to whether the then Attorney General did breach his duty, as well as whether there need to be cabinet approvals before this Chief Parliamentary Counsel approves the bills, drafts bills in Parliament. And I have with me via the web none other than one of my favorite guests, Mrs. Karen Nunez-Tesheira. She is joining us again via the web, and of course she is no stranger to this station. She's an attorney at law, former lecturer. She's an author as well as she was a government minister. So within that context, I have Ms. Nunez-Tesheira with me. Good morning.
Good morning, Rhonda. Good morning to your viewers. And as usual, I'm happy to be here and draw any light I can on the current imbroglio, as I would call it, which I think we all stand to benefit from the outcome of it. I think it would create the certainty that appears to be missing in this particular matter of the drafting of bills and whether, in particular, they need cabinet approval before they are presented to the Parliament. I think that is the issue between himself, that is the Attorney General, and the Chief Parliamentary Counsel, Mr. Ian McIntyre. So I don't really want to go down, use this program to go into personalities, but really to use this as an opportunity to see whether the CPC was right to take his position, or was the Attorney General correct in insisting and threatening, which he did, legal proceedings, disciplinary proceedings against him by letter of March 11th, 2022.
And let's get a bit of overview. We understand that the Attorney General, according to our Constitution, what comprises the government, and you can correct me, is the Prime Minister, the swearing of the Prime Minister and the Attorney General. That comprises the cabinet with respect to our Constitution. So tell us the importance of how serious the role of the Attorney General is in our jurisdiction.
Yeah, so I think part of the issue, as you would have pointed out, is that in the Constitution, the only two offices that are mandated by the Constitution, of course, is your Prime Minister and the Attorney General. But then one has to look at why the Attorney General. Governments have policies. That's how you have different administrations. They win the elections, and hopefully they did so by saying that they have policies, that they're going to make law and, make everything better for the country. And there's only one way to make a policy enforceable, and that is through making it a law. And so the Attorney General's role, without question, is to have a cabinet note, which would have gone through the cabinet approval for him to take it to the AG, Attorney General's department, which is made up of a number of departments, one of which is the Chief Parliamentary Counsel, for the purposes of drafting the bill. That is why I think one cannot leave out in my view, the Attorney General's role has been highlighted, because it is only through the passing of legislation that a government's policy becomes a law. So that now, when you've asked me if you want me to go ahead, or you can ask me a particular question. Insofar as the role of the Attorney General, it really is one that creates a duality of functions, and it really creates that level of uncertainty that we have seen and which the United Kingdom has sought to correct. So that in our country still, and that is in our constitution, the Attorney General is a member of Parliament. He is a member of the cabinet. He is also a political appointee because he comes from the party that is now in power. But he's also the advisor to the government on legal issues, a legal advisor, as well as the protector of the interests of the public. So therein lies the, I wouldn't say the conflict, but therein lies the tension between the two roles. And I would like to say that insofar as the role of Attorney General developed from, I think, from the 12th century in the United Kingdom and eventually morphed into what it is today, the whole function and focus of the Office of the Attorney General was as an advisor to the Crown in relation to legal issues. So, of course, Attorney General has two major departments insofar as civil matters are concerned to assist, which is the Solicitor General's department, Chief State Solicitors, and of course he can always have consultants to assist when it is a matter that requires that level of expertise. And then you also have in his department the DPP, but he cannot instruct the DPP at all because the DPP is constitutionally protected. It's a creature of statute, and he has no authority whatsoever over the DPP, even though he falls under his department. So I should say, yes, go ahead, sorry.
Let's deal with the issue, or rather the particular office holders within the Attorney General office. Of course, these are public servants. They are directed, is it that they are directed by the Attorney General, or is it that they can pursue their role separate and apart?
I don't think they can pursue, I think except for the DPP, which is, I think it's Section 90 of the Constitution, because at one time the Attorney General was not only advising on civil, but also on criminal matters. So that in order to ensure, and that was the deliberate decision that was made to put in the Constitution that that insofar as the DPP is concerned, he does not answer to the Attorney General. The Attorney General cannot influence him, direct him at all. And in fact, that came up with the Nelson issue, that in this letter of saying that he was going to give him protection, he was even careful to say that he would try to persuade the DPP not to pursue criminal proceedings, because he understood that he could not direct the DPP. But insofar as the other departments are concerned, they are there to assist the Attorney General in carrying out his function as a legal advisor. And I want to say on that, in England, the Attorney General is no longer a member of the government. He is not a member of he or she is not a member of cabinet, doesn't attend cabinet meetings. And the reason for that is because it's to address the same issue that we're looking at. If he is to do both, be a protector of the interests of the public, as well as be an advisor to the government, they believe that there should be enough distance between himself and the cabinet, the government, when advising the government. So in England, it was done deliberately. He's not, an Attorney General is not a member of the government, is not a member of cabinet. And that is the reason for that. But I've also looked at, of course, in England, there's also the role of the Lord Chancellor as well, who really functions, or sometimes as an advisor. I mean, he's the conduit between the legislative and the executive, legislature and the executive. So therefore, the role of the so you have to understand, with the Attorney General, unlike other senior positions like the Chief Parliamentary Counsel, the Chief State Solicitor, Solicitor General, judges, the DPP, they get the appointment through the Judicial and Legal Service Commission. It's stated very clearly in the Constitution that those appointments are done by the Judicial and Legal Service Commission. With regard to our Attorney General, his appointment comes from the politicians, comes from him being part of the party. so that it is that juxtaposition, that tension between his political loyalties and his role as a defender of the public, that they would want to make that separation. The all these other appointees, whether it be a judge, whether it be the Solicitor General, all these heads of departments are not appointed by the Attorney General. They're appointed by the Judicial and Legal Service Commission, head of which still is the Chief Justice. And so I think that is where the difference lies. He is a political animal, and that is why the tension exists. And that is why efforts were made in the United Kingdom to take him out as far as possible, to distance him from that rule, so that
of course we know now
he could be seen to be really doing what he's supposed to do, advise the government, yes, but also protect the interests of the people. And that is a difficult
in the UK
situation that creates its own tension.
Yes, and I know now in the UK, the Attorney General is a female. I can't remember her name exactly. Sorry, I know that in the UK now, the Attorney General is a female who is an MP as well, as part of the government, maybe not the cabinet. Now, I want to take a break now, and maybe when we get back, we will continue with respect to the issue at hand. You are watching Strictly Legal on WESN Content Capital. We'll be right back. And welcome back. You're watching Strictly Legal. And my guest is Mrs. Karen Nunez-Tesheira. We are speaking about the role of the Attorney General, his legal responsibility and authority. Before the break, we were speaking about the general role of what the Attorney General is and what does he do. Now, let's get right into the aspect of legislative drafting. Now, we understand that the Attorney General, one of his roles and function is to preside over legislative drafting as per policy of the government. Now, Karen, could you just tell us or shed some more light in terms of this particular aspect?
Sure. I think the whole thing began, as you know, with a March 11th letter from the Attorney General to the head of CPC, Mr. McIntyre, who has an impeccable reputation. I must say, I know him personally and brought him in the Ministry of Finance to do our drafting, and I can say nothing but the best about him in his character, his ability. So just get that out of the way. But yes, he was instructing him to prepare bills to take to Parliament regarding other ministry, I think Ministry of National Security. The Chief Parliamentary Counsel refused to do so on the basis that he needed cabinet approval to do that, and his entire department supported him. It reached a point where he got a letter telling him, threatening him with disciplinary proceedings if he did not do as the Attorney General had instructed, at which point he wrote to the Judicial and Legal Service Commission, who appointed him, that is CPC. And after having written to them, then it is when on March the 16th, that the then AG, who was removed from that position, but we're not getting into that political aspect, sought to bring disciplinary proceedings. So the issue is, on what basis could the Chief Parliamentary Counsel refuse to draft the bill without Parliament's cabinet's approval?
And then
I know I've heard the arguments talking about convention and tradition. So we know one of the sources of law is the law of custom. I'm not too sure how that goes in Trinidad because we're not around for very long, but then that is a relative concept. But I don't think we need to go down that path. I think we need to look first at your constitution. And the first thing that helps me in making that statement is Section 75 of our constitution, where it says that the cabinet shall have general direction and control of the government and shall be collectively responsible, therefore, to Parliament. So I want to stress the word collectively responsible. So what it means is that it is not a one-man show, and it has never been a one-man show. It's not, the Attorney General may have bills that he wants, but he still has to bring it to the cabinet, because at the end of the day, it is not a government of one. It is a government of the cabinet headed by the Prime Minister. And therefore, you cannot policy of a government which is being made law must get the approval of the members of the cabinet. And if one has any doubt about the collective response, which is the actual words used in the legislation that I mentioned, in the Constitution, it does say, as the titular head of the legal service, and when a matter is brought against the government in civil matters, the Attorney General is the person who you sue as titular head. When it comes to criminal matters, because of the separation and the constitutional insulation of the DPP, it is the state. But if one has any doubt as to whether, just on pure logic, that is the case, one doesn't have to go very far. One can go to the website of the parliamentary website, which I found very peculiar that no one had mentioned it, because when you go to it, they go through what is called drafting of a bill. Yes. And they tell you, well, a bill could come to the attention of the minister by various means. But once the minister feels it's something that should form policy and part of the government's, something that the government should want to enforce, and the best way to do that, of course, is by making it law, he can then bring a note to cabinet. And before he brings a note to cabinet, his ministry, whether it's agriculture, energy, tourism, whichever ministry, because I was in the Ministry of Finance, that's what we did, you prepared a cabinet note, and the cabinet note would explain what was the note about, what was the policy, what you wanted to achieve, and so on. That note would then be taken to the cabinet meeting, and then when it was taken to the cabinet meeting, there would then be discussion. If the cabinet and the head of cabinet felt it was a very detailed bill and required further consideration, then there was finance and general purpose meetings on the Monday where they would further consider the note. If at the end of the day, when they had the next cabinet meeting, there was approval of that note and any amendments made, both at the time of the note being sent to cabinet to consider, and now at the time when cabinet is now asking to be approve the note to send it to parliament, at both stages, at the first stage, it ends with a request in the first stage, with a request to the Attorney General to have the bill drafted. That's a request at that stage. Once the note has been approved and you have a cabinet minute, it's no longer a request. It is an instruction to the Attorney General to have the requisite bill drafted representing the policy.
Right. So let's stop there.
That is the role of AG, and it's set out in the on the website of the parliamentary website.
Right. So Karen, so what is the bill? So let me just ask a question. Okay. So therefore, the cabinet instructs the AG to draft a particular piece of legislation. Now we have the instance here where it appears that the AG would have instructed the Chief Parliamentary Counsel to draft pieces of legislation, and the Parliamentary Counsel is basically stating that with what approval, because there's a custom. Now, where
it's not only a custom, I go beyond custom. I mean, if the legislation talks about collective responsibility of the government, I don't know how policy that you want to make an act can be considered a thing of collective responsibility when I had no say and I was not part of the decision as to whether I agree, because there are notes that come to cabinet that actually people have to withdraw, members of parliament or the minister has to withdraw the note because it has not gotten approval, or he has to amend the note. And because it's not his note, it's the note of the government, collective responsibility. And that is what Section 75 says in the Constitution. So you cannot speak. That term collective responsibility is not a term of art. It is in your Constitution as Section 75. And furthermore, the note says, this is what it says, with a request for the Attorney General to have the bill, because it is only his department that drafts bills. And the department that is responsible for drafting of bills will be the CPC. Once the CPC gets instruction, he is going to want to see the note, because the note will advise him exactly the considerations, what to look at if there's a bill already similar, and look at whether it needs a 3/5 majority. He has to now look at the note that has been approved and then try to do the drafting. And when they are doing the drafting, and this is from experience, and I expect it's still done, when his first draft is done for the ministry, there is a legislative committee And the legislative committee is made up of certain members of the cabinet who sit there and they meet with the draftspersons and the cabinet and the minister and some of his staff as advisors, technical staff, and go through the bill. We did that with the property tax, for example. Go through the bill, see if it needs changes, see if it needs amendments. You go back, come back to the legislative committee, and once they sign off, they say, okay, we're good with it. Then you can then prepare the note to cabinet for the cabinet to approve the policy and then to instruct the AG's department, the AG, because it's his department who's going to draft the bill, instruct him to prepare the bill. So the AG doesn't do it's the CPC that will then draft the bill, but he's going to look for the approval from the cabinet that gives him the authority to draft this bill. And that is what this whole thing has been about. My understanding is that the Attorney General seems to think that as Attorney General, he can go willy-nilly to CPC and verbally, that's what I've read, verbally or in writing, and instruct him to draft a bill. And he has been embarrassed so many times with bills that even the clerk of the House had to give him a bill that she did not pass through the cabinet and told him that there were so many flaws in it that she could not possibly bring that before the cabinet, before the parliament. And that is the advantage of going through the CPC, going through cabinet. It's government policy, not your policy. It's the government. But how is it going to be government policy if you have not allowed the cabinet, which forms the government, to determine whether they agree with the policy and the final drafting of that policy, so that you, as the Attorney General, because the Parliamentary Counsel is in your office, to now go ahead and draft. But he has to have instructions, and it cannot just be your instructions. It has to be from the cabinet note.
Yes, but would you not say
I don't understand this at all.
Will you not say that it is, would you agree or not agree that it is insubordination for the CPC to disregard the directive of his boss, the Attorney General, even though, yes, there's a particular cabinet procedure, but if bills are supposed to be rushed, let's say there's a particular bill that has to be sent through Parliament as soon as possible, and there are so many different moving parts. How does that address? How is that being addressed?
Right. So there is acceptance, and that there would never be the Attorney General on his own, because he's an advisor to the government. And therefore, if there's a bill that has that urgency, like you need to have a state of emergency, we don't have time to go through all of that, you go to the Prime Minister, and the Prime Minister will give the instruction. And it's only in those unique circumstances that one would do that. But I am not aware that since this matter has been going through a protracted period, that the issue with the AG and the CPC has anything to do with the urgency of the bill. It has to do with the authority of the Attorney General. And by the way, when you go to the parliamentary website, I actually wrote it down, because they said, because I think it's important to say, when the draft bill meets the satisfaction of the ministry's approval of a cabinet note, must, the word is used, must be sought before it is sent to the House of Representatives or Senate. The word is must. Must is like shall. Yes. So there's no question that the Parliament understands what the process is. There's no question of collective responsibility. So I think the Attorney General misunderstands his role when it comes to drafting a bill, because bills are policy, and policy is a government policy, and the government policy starts with the cabinet giving its approval and then a cabinet minute. So I don't see how I cannot understand why he thinks, and it's almost like bullying. So what has happened is that the CPC and his entire staff have written to the judicial, and he has written, the CPC, given the threat of being disciplined for not complying with the instructions of the Attorney General. His argument is, well, are those instructions lawful? Are those instructions lawful? And so he has gone to the GLSE for them to look at it, and the government, rightfully, through Reginald Armour as the new Attorney General, has asked, I'm not sure if he should have had, no offense to Mr. Pomina, that was my... But his very close relationship with the Prime Minister, whether that was a good choice, because this matter has so much implication moving forward.
Well,
and
that was...
we don't want any taint of
yeah, precisely,
of any bias.
No, that was my next question in terms of whether using the attorneys, who were the attorneys of the then AG, to give an opinion is a conflict of interest, or whether or not that opinion will be independent. Notwithstanding that it is a legal opinion.
I understand that. And that has a lot to do, as you very well know, Rondell, the reputation of the attorney. We all know that. Things you can't say, that's why we have the law of defamation, no matter what the Constitution says about freedom of expression.
Indeed.
Right? We know that we have to be careful.
Yes.
I don't think anyone can question the bona fides or the capacity or the ability of Douglas Menace. I don't think that in any way, and let me just be transparent, he is my lawyer and has been my lawyer in my matter, which is still ongoing and is now in the Privy Council. And one of the reasons that he has been my lawyer and continues to be my lawyer, quite apart from his ability, which I have no doubt, is because I believe in his being a person that will do the right thing. So I think when it comes to Douglas Mendes, even how he acted in the matter in the Law Association and having to take positions against even the Chief Justice, I mean, that in itself speaks volumes. To prepare to go up against the Chief Justice all the way to the Privy Council. I don't have any reservations so much when it comes to Douglas' independence. I don't know if Michael Pomina was a good choice. He is the head of Heritage, and it is a well-known fact that he is seen to be the advisor to the Prime Minister. No. And I think, but he's in the same chambers as Douglas, so that gives me a sense of unease in choosing Michael Pomina. And I mean no offense to him, I'm just looking at what people want.
Yeah, the perception.
They want transparency or the appearance of transparency.
Correct. So let's look at the end result. What is the end result? Let's say, for instance, the opinion seeks to damage, or rather to confirm, that the then AG usurped his authority and proper procedure wasn't followed. Is it that now the AG, although he's reassigned, can be called to resign? Or that is a political decision?
Okay, so my answer, and this is the politician in me, my answer is this. This Attorney General has had several stains against him. We know in divorce, you talk about unreasonable behavior. Starting with his children on the range, and the other AG say, no, we never got that kind of training. The issue with the Adrian Schoon, the issue with the legal notice 183, the issue with, you can go on and on with the mandatory vaccination they had to pull away from, that you could go in a person's house and arrest them. Oh, God, there's so much thing. Then he's supposed to advise, even if he sends it out to a consultant, at the end of the day, he has to look it over and say, Prime Minister, this is hogwash, or this is not going to stand up, So, you really have to wonder what, but obviously the Prime Minister considers him an important member of his cabinet for whatever reason. But I think this issue with the CPC and Mr. McIntyre, who is apolitical, which cannot be brought into the political fray. You can't call the UNC or Kamla as responsible for this. It's a simple matter, and the manner, anybody who knows Mr. McIntyre, he is a public servant. He's a consultant to many governments. You can't bring him down to that level, and he can't be brought on that level. So I think, to answer your question, I think when the Prime Minister, and this is just my opinion, realized that this was one battle that he could not politicize, and this was one battle that he was likely to lose, and the AG was likely to get a lot of egg on his face, the final coup de grace, as they say, I think he took a quick move and moved them out, because moved them across. Because the next way he would have had to do is not move him across, but move him out. And I think when the advice is given, I hope, and it is my hope, and I believe it will be, that both certainly Douglas Menace and I will not take a personal look at it. They will look at this as an opportunity that has presented itself to create certainty in the role of cabinet in the preparation of a bill to Parliament.
Definitely.
And that it came about under these circumstances, and it will be more focusing on the lack of certainty and the opportunity now to create the certainty, rather than go down looking at Mr. McIntyre and Mr. Tunan. I don't think there's anything to be gained for that, because I don't think the Prime Minister wants to get rid of the
yes.
of Mr. Faris Al Rawi. For whatever reason, he wants him in there.
Yes.
And he will have no case against Mr. McIntyre. So his thing was to just move him across, get him out of the way, and hopefully the advice that they will give will focus on the law and not on the personalities.
Indeed. Unfortunately, we are out of time, but this is a very pertinent topic and an issue that I'm sure we'll be looking at in the future, because there's an opinion that should give some context and some finality to it, at least there. Hopefully, if not, then it may have to go to the courts for its interpretation. So thank you so much, Mrs. Nunez-Tesheira, former Minister of Government, as well as an attorney at law. All the best. Thank you.
Thank you very much. Good to be with you and good to be with your audience.
Right, so guys, it's a wrap. You have been watching Strictly Legal on WESN Content Capital. Be viewing next week for a fresh episode. Of course, you can watch us on WESN CC and all social media platforms, including our podcast. Do be safe. Have a good day. Bye.